Well, good evening, everyone. Welcome to the first MCCBA seminar of 2022. If the MCCBA has not previously crossed your radar, it was established by Midlands barristers in 1991 with the aim of promoting chancery and commercial work in the Midlands. And it's taken a leading role in supporting the establishment and development of the specialist courts in the Midlands, which we're very proud of. Now, it's a shame in some ways we're doing things virtually tonight. It does have the advantage we're able to welcome people from far and wide who might not otherwise be able to make it to Birmingham on a wet Tuesday night. Now, the first speaker this evening is Mr. Justice Zacaroli, now supervising judge for the BPC in the Midlands. This is something of a homecoming for the judge, having been born locally in Sutton Coldfield and educated at Bishop Walsh Comprehensive School. Now, as a barrister at South Square, Mr. Justice Zacaroli was instructed on many of the seminal insolvency cases, including a litany of layman cases and MF Global as well, which will be known to many of you. Having been appointed to the High Court in November 2017, it's really no surprise he's dealt with many important insolvency cases, including, particularly relevant to tonight, Re Hurricane, in which he refused to sanction a restructuring plan because the dissenting shareholders would not be better off under the plan. And then New Look and Regis, which concerned his consideration in detail of alleged unfairness and irregularities in relation to retail CVAs. The second speaker is Chris Umfreville, Senior Lecturer in Law at Aston University, who has a focus on corporate insolvency law. Chris is particularly well qualified to talk about the future of CVAs because he has recently carried out detailed research for R3, leading to a paper titled CVAs Evaluating Success and Failure. I'm pleased to say that Chris is also an adopted local, having studied history at Birmingham University and then been a solicitor at Eversheds in Birmingham until 2012. There's going to be, I hope, an opportunity for questions at the end. So please do send those through on the Q&A function, and then we'll try and deal with as many as we can. But first, for around about 20 minutes, Mr. Justice Zacaroli, in relation to the Part 26A schemes and how that might apply to SMEs. Judge, thank you very much.
Thank you. Good evening, everyone, and I'm very pleased to be with you, even if it's only virtually. I will be talking about the Part 26A restructuring plan and its interrelation with CVAs, particularly in the retail sector. But let me start with what we've had for a long time. That's the scheme of arrangement. It's been with us for over 150 years. It's based, as you all know, on the simplest of statutory language, which has been unchanged for most of that time. Basically, if more than 75% in number and more than half in value of the company's creditors or members, or any class of them, agree to a compromise or arrangement with the company, and if the court sanctions it, then that compromise or arrangement is binding on all the creditors or the members or the relevant class. Its importance lies in the fact that it enables creditors' legal rights against the company to be varied against their wishes, provided that a sufficient majority of others in the same or similar position to it are happy to go along with that variation. The critical element in that sentence is that it's only if the majority and minority are in a sufficiently similar position that the variation in rights is binding on the latter. And so much of the developed case law in the area has focused on what it means to have rights that are sufficiently similar to others so that you can be placed in the same class, and the decision of those others is binding on you. Now, whereas a CVA can only be entered into between a company and all its creditors, and I'll come back to that, a scheme can be entered into with only a class or certain classes of creditors. And it's for the company to decide, essentially, with whom it would enter into a scheme. Provided its decision is based on sound commercial reasons, the court is unlikely to interfere with that. Critically, however, a scheme could only be sanctioned if all of the classes of creditors voted in favour by the requisite majority. So let's say, for example, the company has two classes of creditors, secured and unsecured, and it proposes a scheme with each class, offering perhaps the secured creditors a new security package and offering the unsecured creditors a dividend of 60p in the pound. It's only if both classes vote in favour that the scheme is capable of being sanctioned at all. The fundamental development introduced in 2020 by the Part 26A plan is that it enables the court to sanction the plan even if one, some, or as many as all but one of the classes vote against it. Now, in the past 30 years or so, the scheme has been the popular choice for high-value financial restructurings. These have tended to produce enormous, complex documentation, the product of negotiation between different stakeholders, often over many months and at great expense. Schemes will also involve 2 trips to court, one to convene meetings of creditors and one to sanction the scheme if it's approved by the requisite majorities. For those reasons, schemes of arrangement have typically been seen as out of reach for small and medium-sized companies. And that's traditionally contrasted with the way in which CVAs have been used. As you will all know, CVAs grew, it seems, as something of an afterthought if one looks at the court report, out of IVAs introduced in the 1986 Insolvency Act. And they've been the choice for simple cases, usually involving small and medium-sized companies, ever since. The proposal for a CVA has tended to be a relatively short document, setting out just the basics as required by the rules of court. There need be no involvement of the court at all, apart from filing reports with it, at least unless and until there is objection taken to a voting decision, for example, at a meeting, or an application is made to challenge the CVA after the event. There have been exceptions, however, where CVAs have been used in more complex cases. One major example was in the 1990s in the huge federal mogul insolvency. But more recently, looking back over the last maybe 5 to 10 years, there's been quite a growth in the use of CVAs in larger cases involving retail companies with disparate groups of creditors, including usually a large number of landlords. That has proved, to say the least, controversial. Now, the 2 questions I want to explore a little in this talk is whether the new restructuring plan is, first of all, a better restructuring tool than a CVA for such complex cases in which the CVAs have been used more recently. And secondly, is it a tool that can be better used for smaller and medium-sized companies? But first, a bit about what the restructuring plan entails. A restructuring plan must involve, like a scheme, a compromise or arrangement between the creditors and the company. And I'll focus on creditors, although it does involve members as well, but we're really concerned in the insolvency sphere mostly with creditors. And those terms, compromise or arrangement, will be interpreted the same way. Unlike schemes, though, there are 2 threshold conditions for a restructuring plan. The first is that the company has encountered or is likely to encounter financial difficulties which are affecting or will or may affect its ability to carry on business as a going concern. The second is the purpose of the compromise or arrangement is to eliminate, reduce, or prevent or mitigate the effect of those difficulties. These are relatively low hurdles to overcome. Their presence, however, has had one important consequence. As a result of a decision of mine a year ago in Regate Group, and as a result of these conditions relating to financial difficulties, I concluded that the plan is an insolvency proceeding so as to fall within the bankruptcy exception in the Lugano and Brussels conventions. That's in contrast to schemes of arrangement. That was thought to be a significant development as it would preclude recognition of restructuring plans in Europe under those conventions. Since, however, post-Brexit, the UK is no longer a party to either of them, and our request to join the Lugano Convention in our own right has so far been refused, the significance in practice is much reduced. Now, as with schemes, a plan is made either with all creditors or a class of creditors, or classes of them. And as with schemes, creditors are in the same class if their rights against the company are sufficiently similar they can consult together on the scheme in their common interest. Every creditor who is affected by the plan must be invited to a meeting to consider it, unless the company can show that a particular class of creditors has no economic interest in the company at all. For example, they are subordinated to others and the value breaks within that other group of creditors. The statutory majority for a plan is the same as for a scheme. 75% by value of each class must vote in favour, except there's no majority by number. The big difference, as I've intimated, however, is the cross-class cram-down under section 901G. This applies where there is a dissenting class, that is 75% majority is not achieved at one or more class meetings. The court can still sanction the plan if 2 conditions are satisfied. The first is if sanctioned, none of the dissenting class would be any worse off than they would be in the event of the relevant alternative. and relevant alternative is defined as whatever the court considers would be most likely to occur in relation to the company if the plan were not sanctioned. And secondly, the arrangement must have been agreed by the requisite majority at one class meeting, at least one, of creditors who would receive a payment or have a genuine economic interest in the company in the event of the relevant alternative. The latter will usually be easy to establish, but the former can be more difficult. In the plain case, where the alternative to the plan is an immediate liquidation, then the no worse off question is usually just a question of valuing assets and liabilities and working out the likely dividend in that liquidation. But where the alternative to the plan is less straightforward, more difficult questions can arise. That was the position in the hurricane case that James just mentioned. There it was argued that shareholders would get nothing without the plan, and therefore they would get whatever very small amount they might get in the plan was put them in no worse off position. It was common ground that the relevant alternative, far from being an immediate liquidation, was a profitable trading for many more months at least. In the end, I decided there were too many variables over that quite lengthy period, including oil production rates, it was an oil production company, future oil price, and possible other ways of dealing with the maturity of bonds in a year's time. There were too many variables in all those areas to conclude that shareholders would be no worse off than without the plan. And that's the reason it was not sanctioned. Perhaps more interesting, however, is the question as to what the court does if the thresholds are met. There is then a broad discretion to be exercised. And this is quite novel territory for the courts. Although such learning as currently exists in the Part 26A arena suggests that principles developed in CVAs can and will be instructive. For example, it cannot be sufficient to sanction a plan that you can show that the creditors in the dissenting class or classes are no worse off than they would be if there was no plan, because that's merely a threshold condition. And that compares with the vertical comparator in a CVA, which has been described as the irreducible minimum. In other words, it is almost certain to be unfair prejudice to give a creditor a worse treatment than they would get in a liquidation. So it's a sort of threshold condition for CVAs as well. But the other tool that is commonly used in CVAs, what's been called the horizontal comparator, may also be useful. And this requires you to have regard to differential treatment across different groups of creditors. That's very easy to state, but in practice, it's difficult to know when that will lead to a refusal to sanction the plan, as indeed it's difficult to predict when it will lead to a CVA being found to be unfairly prejudicial. The embryonic learning under Part 26A asks a similar question, but by reference to something which has been termed the restructuring surplus. For this, the starting point is that it's better for somebody, either the company, its shareholders, or one or other group of creditors, for the restructuring plan to succeed, because by definition, it produces a better outcome for them than it would in a liquidation or the relevant alternative. The restructuring surplus is that value which is preserved or created by avoiding the liquidation. And the question to ask is whether the proposed plan is one which fairly distributes that surplus among the different groups of creditors. This is a question of great relevance in the retail cases I mentioned earlier, where typically a company has at least two groups of creditors. One will be ordinary trade creditors, where it is said that they need to be paid in full for the company to carry on trading. And the other is landlords who are being asked to take a substantial haircut on past and future rent. There may often be a third group, secured creditors. Now, two cases within a week of each other last year raised these sorts of questions, but interestingly, one in the context of a Part 26A plan, and that was the Virgin Active case, and one in the context of CVA, which was New Look, itself hot on the heels of the other decision in the CVA context, Regis. I shall be careful what I say about New Look in particular, noting that the Court of Appeal hearing in it is due to start, I think, in a couple of weeks' time. So whatever I may say might soon be out of date. But it prompts me to ask whether, in light of the particular complexities which are raised by CVAs of this type, which is the better tool, CVAs or restructuring plans? The CVA suffers from the following drawbacks, again, subject to what the Court of Appeal tells us. The CVA was undoubtedly designed for simple, probably low-value cases. as I say, it grew out really of the IVAs, which were the first thing to be thought of. But the time limits for obtaining a nominees report, for reporting to the court, and for holding meetings is very compressed. Nominees reports are generally relatively short form. The insolvency rules are heavily prescriptive as to what must be in them, but they tend not to provide anything like the level of detail on particular issues that the explanatory statements in schemes of arrangement would typically contain. Given the short timescales involved, there is no real scope for obtaining further information, documentation, or evidence. Special groups of creditors, such as landlords, may find themselves thrown into a process with little opportunity to engage on the terms of the proposal or to provide their own evidence to counter what the company says. In any event, the process is likely to be a fait accompli, there being overwhelming reasons for other creditor groups, such as those that will be paid in full or stamped substantially in full, to vote in favour, irrespective of what evidence the landlords might present. And there will usually be enough of these other creditors for their vote to be decisive. This goes to the very core of the complaint made in both the Regis and New Look CVAs, that they were achieved by votes of creditors who were either unimpaired or substantially less impaired than the landlords, and that breached the fundamental principle of majority rule that I mentioned earlier, which one sees throughout the scheme of arrangement jurisdiction, that the majority will bind the minority only where their rights are sufficiently similar. Now, the plan procedure addresses at least some of these points. Meetings take place only between creditors who have sufficiently similar rights. That is the same as with the scheme of arrangement. So it's highly unlikely, or should be impossible, that landlords would be in the same meeting as unsecured creditors or secured creditors. The court is involved at a much earlier stage and can ensure that the information provided to creditors through the explanatory statement is sufficiently detailed to provide all necessary information. It can order further disclosure from the company, and it can permit time for opposing creditors to put together their own evidence in opposition before any meetings take place. There is no question of a fait accompli because the court will scrutinise the fairness of the plan before it's sanctioned. On the other hand, the plan procedure does not actually cure the core problem, which was the complaint in Regis and New Look, as seen by the landlords of a CVA, because although each meeting must involve only creditors with sufficiently similar rights, landlords can nevertheless find themselves in a plan that is only voted through by others with vastly different rights because of the operation of the cross-class cram-down. That is, the other meetings of creditors with similar rights vote in favour, and that is enough to enable the court to ignore the objecting vote by the landlords. That is, in fact, what happened in the Virgin Active case. But I would suggest that the Part 26A plan procedure is an inherently fairer process than the CVA, precisely because the plan allows for the question of what is a fair approach to be established before the restructuring is put in place. The separate groups of creditors have a real voice in negotiations before the court hearings because the company cannot be guaranteed that the cram-down will ultimately be applied. It necessarily has to engage with the different groups of creditors. And that gives rise to the possibility that a better, fairer deal might come out of those negotiations, or later might come out of subsequent negotiations if the court has a negative reaction to the plan as presented. Although it's not the court's job to devise alternative plans to the one that's being presented, a negative reaction to the one that's been presented may well cause the parties to go away and come up with something better. In so doing, the court would be assessing the fundamental question as to what is the fairest distribution of the restructuring surplus. And that in turn would probably require an examination of whose sacrifice is it that's necessary in order to enable the plan to go through, and what share of the surplus should justify that, should that justify for them. The other major advantage of the plan is certainty. Now, the difference between New Look and Virgin Active is instructive here. Just to look at the timing, the New Look CVA was implemented in September 2020. The expedited challenge was heard in March 2021. Judgment was delivered in May 2021. The appeal is coming on before the Court of Appeal in March 2022. This brings home the fundamental point that there can be no certainty in a CVA if it is challenged within the short period allowed for challenges, because it can remain vulnerable to being struck down for months or even years after it's voted through. In contrast, Virgin Active was done and dusted in a matter of weeks last year. There is no prospect of a challenge to a restructuring plan after it's been sanctioned. There's always the possibility of an appeal, although in practice appeals against scheme decisions are rare. But, and this takes me to my last point, the advantages of the plan procedure come at a cost. Certainly if the approach taken to them is the same as that taken to schemes of arrangement I've already outlined. Where the CVA is used in a high-value complex restructuring, then I think there's a good argument that to use the truncated and simplified procedure of a CVA is a false economy. A, because you may well find yourself in very expensive litigation seeking to challenge the CVA, but also because the complexities of the case should be reflected in the greater attention to detail that a restructuring plan demands. But in lower value cases, the question I would ask is whether practitioners and the courts between them can make the restructuring plan procedure work more efficiently and at lower cost than the scheme jurisdiction has been able to operate, so that it may become an effective tool for SMEs. What would need to happen? Well, just 4 ideas. First of all, practitioners need to take a pragmatic approach to producing scheme documentation. One should start with the CVA model, adding that which is strictly necessary, rather than starting at the opposite end of the spectrum with the scheme of arrangement template. Secondly, the court needs to be equally pragmatic in what it requires by that documentation, not putting too much of a burden on the promoters of the plan, and permitting the bare minimum by way of explanation. I should note that the scheme practice direction, implemented at the same time as the Part 26A process, expressly requires the explanatory statement to be in, and I quote, a style and format appropriate to the case. That includes where the case is a simple and low value one, it being simple over long, not over long, and not complex. The third issue is equally the court needs to take a pragmatic approach to objectors. For example, to applications for disclosure or to reduce factual or expert evidence in opposition to the companies. The process could quite quickly get out of hand and become prohibitively expensive if the application is treated too much like ordinary litigation. Even in high value cases, it's been said on more than one occasion that we should not allow the plan procedure to become so complex that it falls over its own feet, remembering that the process is very often required in cases of some urgency. It's always important to focus on the purpose of the exercise when considering how much disclosure, how much evidence to allow, that it is to enable a business in distress to be restructured. And finally, perhaps consideration can be given to whether 2 huge set-piece hearings are appropriate, recognizing that the simple task of all the parties getting together, instructing solicitors and barristers to attend court is necessarily expensive. Could some of it be done by applications on paper, certainly in the absence of opposition? So those are just a few thoughts. But in summary, I'd say this is a procedure which has potential. I'll pause there and hand over to Chris.
Thank you, Tony, very much. I'm just going to open my slides and share my screen. Just give me a moment. Hopefully you can now see my slides on the screen, and we should be good to go. Well, thank you for that, Tony, for that really interesting, revealing overview of how the Part 26A restructuring plan could be utilised by SMEs as an alternative to the CVA. And my part of the contribution to this evening, I'm going to take a look at the future of the CVA, then in light of perhaps what Tony's just talked about, if it is to be used more by SMEs, and certainly some of those larger CVAs we've talked about would be more appropriate perhaps as a Part 26A restructuring, and reflect on some of the recent developments and think about what the future of CVA might be. Now, the purpose isn't here to be necessarily an advocate for the CVA and to bang the CVA drum, but rather to reflect on recent developments and how they may influence the future use of the CVA for good or for bad. I'm not going to say that I've got all of the answers here either, rather just trying to sort of put some thoughts out and perhaps have some discussion with the group tonight. Perhaps, you know, some of these issues that I'm going to identify are merely theoretical challenges and opportunities. I'd be interested to hear how you feel that they bear out practically. James mentioned that I was a practitioner in Birmingham, but I'm well aware that it's many years since I've had to sort of concern myself with the billable hour. So I'd welcome the view from practitioners on some of the points that I'm going to talk about. Okay, so first of all, I thought it would be interesting to get some perspective on the matter at hand and really think about how the CVA is being used at present. And we saw some really interesting insolvency statistics that were published in December 2021, which revealed that of 1,486 registered company insolvencies in that month, these were dominated by CVLs, which is often the case, but perhaps more so here than usual. So the number of insolvencies in December 21 themselves was 33% higher than the pre-COVID comparator of December 2019. When we break it down by particular processes, we can see that the number of CVLs was at 1,365, which was 73% higher than the number in December 2019. Now, it's important to recognise that compulsory liquidations were 75% lower than in December 2019. So in one part, the CVL increase could be seen because of the restrictions on compulsory winding up due to the protections introduced under SIGA to offer protection during COVID. However, we turn our attention to the rescue process. We see there were just 7 CVAs in December 2021, which is 67% lower than December 2019. And there were 72 administrations, which was 49% lower than December 2019. So the graph on the screen really illustrates how things have gone. And I think the fact that administrations and CVAs are lumped together with a few other things as other insolvencies really shows the lack of prevalence of those processes. So we see a significant increase in CVLs post-COVID, so to speak. So there's lots of activity going on, but it doesn't look like rescue as perhaps was intended by the SIGA 2020 reforms at this stage. So having sort of thought about that, let's turn to look at CVAs more particularly. So if we zoom out and look at the trends over the past decade, we see some further interesting trends emerging. We see CVLs fluctuating between 10 and 12,000 with that recent spike we just mentioned. And we see a general pattern over the last decade of administrations and CVAs in decline. And we zoom in further still, just looking at CVAs and administrations, we can see that decline is more pronounced. So administrations have dropped from over 2,500 in 2011 to just 796 in 2021, while CVAs have dropped quite dramatically from 758 in 2011 to just 115 in 2021. So we currently find ourselves in a situation where, despite the recent high immediate profile for the use of CVAs, we see a clear drop-off in their use over the past decade. I've got limited published data on the use of CVAs and their outcomes, but as James mentioned at the outset, I was involved with Professor Peter Walton and Dr. Lizelle Jacobs in 2018 for the production of a report on behalf of R3 and the ICAW on company voluntary arrangements evaluating success and failure. And as part of this report, we reviewed the outcome of all CVAs commenced in England and Wales in 2013. Now, I think it's important to caveat what I'm about to say with the fact that the CVA landscape has changed somewhat in recent years. So obviously some of what I'm about to say is time limited, so it doesn't necessarily represent some of the use of CVAs now. And in particular, we've seen a real drop-off in numbers as well. I think there were some interesting findings of the 2018 report that are worth highlighting. So we picked 2013 so that we could really follow through some of these CVAs and work out what was happening with them and see how they were actually being used in practice. I think the 5 headline points I've identified here we had the termination rate was interesting. So the CVAs we reviewed, we found that 65.2% of those CVAs were terminated early, and only 18.5% had been implemented during the 4-year period of our survey. And that meant that 16.3% was still ongoing at the 4-year mark of the CVA. Now, that's interesting when we think about the length of the CVAs themselves. So we found anecdotally that typically CVAs we proposed for around 5 years. This appeared in part to be down to the influence of HM Revenue and Customs requiring as long a CVA as possible to try and ensure as great a level of payment. However, the majority of the terminations that we saw, so 2/3 of CVAs terminating early, and the majority of those were terminating within 2 years. So it seemed that CVAs were being set up to run for a long period of time, but they weren't meeting that. And in fact, actually, they were falling over within, say, 24 months. That then birthed further sort of interest when we think about the age of the company that was using CVA. So CVAs were most popular with companies that were between 2 and 4 years old at the time at which the CVAs were being commenced. So these are relatively young companies in the grand scheme of things that find themselves in financial difficulties and having to seek protection in the form of the company voluntary arrangement. But here you have that strange dichotomy where you've got a company which perhaps has been trading for 2 to 4 years, and obviously if it's entered into CVA, it's been experiencing some problems for a little while before that, because you don't just rush to a CVA. And they were agreeing to be bound by stringent terms for the next 5 years. So perhaps the directors would operate under constrained salary requirements. Perhaps they would not be paying dividends to the members, or there'd be restrictions on those. So we'd have a company that had struggled really for a relatively short period of time, committing itself to be bound by stringent terms for a longer period of time that it had already survived for. So perhaps it's not surprising that a significant number of these companies were seeing the CVAs terminate early, and that they were terminating quite early, within 2 years, as I mentioned. Now, one thing we did look at then is we took a deep dive into those early terminations to try and establish what was happening there. Because on face value, you would say that implementation good, termination bad. So termination equals failure. But perhaps that's not actually true. So early termination, yes, the CVA hadn't achieved what it set out to achieve, but you could identify there were some successes coming out of that. So we identified that the longer the CVA went on for, the better returns for the creditors. So obviously money was being collected during the course of the CVA, which was building up a fund for creditors that could be distributed. Now, they weren't receiving everything they were expecting to, but the longer the CVA went on for, the bigger the pot of money that could be returned to creditors. And we found that typically creditors were receiving a better return than they would have, say, if the company had gone into a pre-pack or a liquidation at that stage, when we think about the alternatives that are often put forward. One further thing I'm just going to mention briefly now, something to come back to shortly, is the role of the moratorium in the CVA. Fundamentally, the use of the moratorium was low. So at this stage, we had either the Schedule A1 moratorium for small companies, and around 97% of companies using CVAs at this time were small companies. And you had the administration moratorium as well. So only 18 companies used some form of moratorium before going into the CVA, so 18 out of over 500. But one thing we did identify is that the outcomes were typically much better than the general population where there was a moratorium being used. So when we think about challenges and opportunities for CVAs in a moment, I might revisit this and give more detail there. Ultimately, the report identified that CVAs were a flexible debtor in possession tool that could enhance returns to creditors. And interestingly, where there was perhaps this early termination, it wasn't necessarily a failure, because that could provide a form of soft landing for the creditors of the company, because they have a chance to prepare themselves for the ultimate insolvency, as well as they could support the company through its CVA having a better return. So that's some historic perspective on the use of CVAs and the outcomes achieved by CVAs. Now to turn to the main focus and think about some of the challenges that the CVA faces. I've identified these broadly as the pre-pack, the moratorium, the Crown preference, and the landlords. So first of all, let's think about the challenge faced by CVAs in face of the pre-pack. So for many small companies, a pre-pack realistically is going to be a viable alternative to a CVA, especially if there's no external interest. Obviously, if you pre-pack the business, then you have to market the business for sale and potentially attract outside interest. You have a risk of losing control of the business. But if there is no external interest, or if there's the opportunity to convince the IP that there isn't any external interest, we see in some cases, then we see the value of a pre-pack administration. Now, connected party pre-packs, as we're all aware, are pretty common. So the Graham Review from 2014 looked at administration starting in 2010. It was identified that 63.3% of all pre-packs there were to connected parties. Interesting as well, if we look at the first year or so of the Graham Review reforms, so from November 2015 through to December 2016, there were 371 pre-packs in this point, which 188 or 50% were to a connected party, whereas there were about 338 CVAs in 2016. So connected party pre-packs are common and often dominant in the pre-pack world. So why not pre-pack rather than completing a CVA? Well, as part of the 2018 R3 CVA report, we surveyed 100 pre-packs from 2016. So we will be aware that SIP 16 paragraph 10 requires an insolvency practitioner to keep a detailed record of the reasoning behind both the decision to undertake a pre-package sale and all of the alternatives considered. So we were looking really to identify why had a pre-pack taken place here rather than a CVA. And the most common responses here as to why a CVA wasn't deemed appropriate came down to funding issues with pursuing a CVA, the level of liabilities being carried forward, and generally that company rescue wasn't possible or there wasn't sufficient creditor support. So if we think about this and think about the outcomes of CVAs that I've talked about previously, it's not hard to see really why you would want to pre-pack if you could. So you could remove the liabilities, trade more freely going forward. And also we saw that CVAs were popular amongst those companies between 2 and 4 years old, which were binding themselves to operate under stringent terms for the next 5 years or so. So why would directors want to do that if they had the opportunity to loosen the shackles, so to speak, to avoid being under those strict restraints? Now, interestingly, if we take sort of another angle, you can also see that deferred consideration plays quite a big role in connected party pre-packs. So the Graham Review, as I mentioned, looked at 499 pre-packs from 2010, and of those 63% were connected parties. Of those connected party transactions, 65% involved deferred consideration. So deferred consideration playing quite a big part in pre-packs that we're going through. And interestingly, around 37% of those cases of deferred consideration saw the new company fail within 3 years of the pre-pack going through. So the weight of the deferred consideration appears to have some impact on the viability of the ongoing business. I did some further research in 2018-2019, which was a comparison with the CVA data we found in the 2018 report. So I undertook a sample of 120 connected party pre-packs from 2013 to be able to draw direct comparisons between the outcomes of pre-packs and the outcomes of CVAs. Of the 120 pre-packs that I looked at, I identified that 72% saw deferred consideration coming into play, and 50 of those 86 cases had deferred consideration, which was at least 3/4 of the purchase price. So seeing that a lot of the liabilities in the pre-packs are being deferred. Now, typically that deferred consideration was paid in full, but it was evident from the reports that were being filed that a lot of work had gone into chasing payment of that deferred consideration, and there was a lot of pressure on the businesses to pay that deferred consideration, which appeared to link to a higher failure rate where deferred consideration was being used. So we see that CVAs aren't being pursued because of funding issues, levels of liabilities, But the alternative pre-pack is often being funded by way of deferred consideration, which itself is putting pressures on some of the pre-packed businesses. So you question whether or not deferred consideration is appropriate there, or whether in actual fact they could have pursued a CVA and that would have given better returns to all of the creditors. Another important aspect to consider in relation to the pre-pack and its role in whether or not CVAs are a viable alternative is the recently introduced administration restrictions on disposal, etc., to connected persons regulations introduced last year. You'll all be aware of the provisions of these regulations, predominantly that the IP has to say whether or not they're satisfied or not that the consideration provided is relevant to the property is for the relevant property and the grounds for substantial disposal are reasonable in the circumstances. So we've seen that administrations generally are low at the moment, so it's a bit early to say whether or not that's had a restrictive impact or not. But it does appear that from sort of talking to people involved in the industry that there do seem to be fewer referrals going through in relation to these connected party pre-packs. That then leads on to the alternative form of pre-pack, of a pre-pack liquidation. I'm conscious that time is against me, so I'm just going to go over this reasonably briefly. But there's some interesting work being done by Pride Chanakira, a PhD candidate at Wolverhampton University, who has looked at the impact of the provisions around centre binding and abuse of limited liability, such as the Section 216 provisions against phoenixing, and has identified through some empirical work that recent reforms seem to have led to perhaps some pre-pack liquidations. So as we've moved away from physical creditors meetings, it arguably makes a challenge to companies' choice of liquidator less likely, and therefore with creditors disengaged, perhaps not coordinated, will small liquidations challenge a liquidator. There's also seen a significant number of Rule 22.4 exception notices being filed in the Gazette. This allows the reuse of a company name when the business of the oldco is purchased from the liquidator by giving notice in the Gazette. And in this situation, you wouldn't have to adhere to the stringent requirements of 616. So we've seen recently Gazette notifications in 2021, 521 Rule 2.24 notices, 681 in 2020 and 729 in 2019. So although we see a decline in these notices, if we look at those notices more clearly, some of them appear to be given preemptively, paving the way for a pre-pack liquidation. So one such notice said, it's proposed the company will go into insolvent liquidation on date. We give notice that we're acting and intend to continue to act in all or any of the ways specified in Section 2163 of the Insolvency Act 1986 in connection with or for the purpose of carrying on the whole or substantially the whole of the business of the company, which is to be acquired under arrangements made with the proposed liquidator under the following name. So it appears that this process has been used to facilitate pre-pack liquidations. And as I said, we've seen an increase in CDLs, a decrease in administrations, and a high number of Rule 2.24 notices. So the potential impact of the administration restriction disposals to connected persons regulations might not be to push people towards a CVA, as might have been thought, but rather to push towards a pre-pack liquidation. Also identified the moratorium, and we saw that the R3 report showed that a use of the moratorium was generally positive. So whereas the general population saw a termination rate of 65%, where a Schedule A1 moratorium was used, the termination rate was just 37.5%, so a far higher success rate, so to speak, where a moratorium was used. Where the administration moratorium was used, we saw an even higher implementation rate. So we saw a reluctance to use the moratorium in its former form, but equally saw from a relatively small sample that it did appear to have positive impact on the outcomes of CVAs. So we now have the new Part A1 moratorium, and although only 15 have been used since its inception, it remains to be seen whether that might facilitate more successful CVA outcomes. Okay, and then I think I'll finish with just a mention of the Crown preference, which I think is perhaps one of the big issues facing CVAs now. That we've seen from December 2020, the partial reintroduction of HMRC preferential status for certain taxes, so PAYE, NICs and VAT. Now, we've seen significantly in the past for small company CVAs, the HMRC has been a significant player. We've seen that filter through in terms of its standard requirements becoming the norms. So, for example, 5-year lengths of CVAs and requiring 100% repayment. This often proved a challenge for small CVAs, but one that perhaps could be addressed. But now that HMRC has preferential status, it's less likely that it'd be willing to accept less than it's entitled to under the statute. Stuart Perry of Field Fisher recently wrote an article in Accountancy Age where he raised this and suggested that HMRC hasn't seemed willing to change this perspective, and also raised the suggestion that unsecured creditors would be unlikely to approve a proposal in which they receive less because HMRC gets paid in full, and also directors are unlikely to want to work for controlled sums, again, so that HMRC gets paid in full. So this appears to be something that could have quite a significant impact on the viability of CVAs. I was going to mention briefly the landlord's role, but I think, Tony, you talked quite a lot about the role of the landlord's CVA, so I'll leave that there and just say that there are a number of challenges which could be beneficial to use of CVAs, but also perhaps might make their use more challenging.
Chris, thank you for that. Could you just unshare your screen on that? Yeah, thank you for taking us through those statistics and clearly identifying the challenges that face the CVA. I've got some questions for Mr. Zacaroli in a moment. Perhaps people in the audience, if they've had any recent experience of CVAs and particularly HMRC's attitude towards those and the sort of terms that they're looking to impose, they could pop that in the Q&A and that can be part of our discussion. I know it's rather more difficult than when they're in a room, but we could perhaps try that. Now, Tony, I'm sort of imagining our Midland solicitors in the audience who've got great insolvency experience, but haven't actually done a scheme plan. One of their first questions might be, well, let's say we persuade the board of directors that this is the right way forward. Can they do it in Birmingham? And if they do it in Birmingham, can they get perhaps a High Court judge with experience in this area to come up and do it?
I think the short answer is yes to both of those. There's no reason these things can't be done anywhere in the country. And certainly the business and property courts would make available High Court judges with sufficient experience to come and hear such cases. So I think that, yeah, yes to both questions. I mean, I think there is obviously a wealth of experience in the accountancy, banking, financial and solicitors profession within London in these international schemes, but it isn't rocket science. And certainly in relation to the sorts of cases we're talking about, where it's really, is it appropriate, where you've got a complex CVA, where you've got different groups of creditors, where the CVA is being stretched beyond its probably original boundaries. It's in that sort of case, I say it isn't rocket science. It's a question of just making sure what you did within the CVA fits within this new procedure.
Yes, I like your idea of sort of starting with the CVA model and adopting that, rather than trying to start with the 100 pages of scheme documents you get in the big cases. And I think that's a very good practical way. I guess the second thing the board of directors is going to be saying is, well, how much is this going to cost? And I think there's two aspects to that. One is, what's it going to cost to pay my own lawyers as compared to a CVA? And then secondly, are we potentially liable to have to pay out of the assets of the company the costs of creditors and members who wish to come along and raise objections, good or bad? Do you have any guidance in relation to either of those points?
As to what it will cost the company itself, I don't have any personal experience. It's one thing that I've never had to look at as a judge, because those questions don't come before us. The costs are behind the scenes, or indeed in practice, because it was never an issue. All I knew was what my clerk was charging for me. I never knew what anyone else was charging. So I can't help with that. I think you may be able to give a bit of an indication as to what the cost may be there. There is a risk that the company will be liable to pay someone else's costs if the court decides, come the sanction hearing, that someone else turned up and made good points and either beat down the scheme, in which case they may well be entitled to their costs, or although their contribution was helpful and the court decided to sanction the scheme, in that case there is a risk that the costs would be payable to them as well.
Yeah, I did a little bit of confidential research behind the scenes, and the sort of ballpark figures I've been given for an SME type scheme are probably, with 2 full hearings, which Tony, you indicated we might be able to avoid, is 100 to 150,000, including council's fees. Whereas for a normal CVA, you may be looking at 25 to 30,000, perhaps similar for an out-of-court administration. But I guess one comes back then to the false economy point. If you've got a reasonably interesting SME case, you may get your CVA done relatively quickly, but then look at what happens after the event and the costs that can be incurred in relation to subsequent challenges. So maybe
yes, I agree. Yes, and I've no doubt that the new procedure is not appropriate for the run-of-the-mill case that CVAs have been used for to date. That the CVA, as I say, was designed for the case where you've got a company with all its creditors in essentially the same boat, and you're offering a single deal to them all because they all have to be parties to the CVA. It's when you have competing interests between different groups of creditors, that's, I think, when the CVA, stretched beyond its normal limits, is less appropriate than the new procedure.
And then just a last point before come to Chris and pick up on some of Chris's points. The other thing the board of directors may be interested in is timescales. We kind of know the timescale for a CVA. You're sort of in control of out-of-court administration, and to a certain extent in-court administration if you can line up a judge. What's a sort of realistic timescale for getting through your 2 hearings and having the meetings and getting an approved scheme?
Well, I think there are 2 different time periods to look at. One is the time that it's taken the company, and it's usually a group of creditors who assist in the process, to come up with the scheme in the first place. And that's as long as a piece of string, but dictated by the urgency of the situation. So it could be many months. I've seen schemes which have been developed over many months. It could be a matter of weeks in a case of urgency. Once you get to the stage where you're asking the court for hearings, certainly in London, and I would hope this will be replicated in the regions if schemes are done out there, the court is able to prioritise these hearings, so they get put in a pretty short notice. Generally speaking, you need about 21 days notice for the first hearing, and provided that creditors have had sufficient notice of that hearing, then you wouldn't, in a relatively simple case, you wouldn't need more than 2-3 weeks notice of the meeting that follows, and then the sanction hearing can be a week or shorter after that. So you can be, it's measured in weeks, not months, in the relatively straightforward cases. Obviously, if it's really complicated, it can be longer.
Okay, that's really helpful. Thank you. Well, I hope that's inspired some people to look at these in slightly different ways and the possibility of doing them more locally rather than doing CVAs. Chris, just going back to you, I mean, it seems to me from one of the things I took from your talk is it's almost a matter of education for clients and perhaps even for the revenue. Because the headlines don't look good. You see the reported cases where there's been challenges. You see the decline in the figures over the years. But in fact, when you get under the data, CVAs are still producing reasonable results for creditors, even where there's termination, and better results than liquidation.
I think that's right. From what we've seen, obviously, some of the data I was reporting on is a little bit aged now, so I probably need to update some of those figures. But yeah, I think early engagement is always going to be important to get the best outcome for these sort of processes. The longer you leave it, the worse it will be. And I think part of the importance here is about changing the narrative. I think I've got a personal sort of thing to look at. I might want to do some research around the reporting of insolvency procedures. And I think there's a real sort of negative stigma around all rescue processes in the press. And I think if you think most directors aren't necessarily going to be legally sophisticated and won't understand sort of some of the nuances. And so will they have a negative opinion because of what they see when they pick up the paper or look online? So I think the changing the narrative is important, and educating people as to the benefits of these processes and certainly of early engagement as well.
I wonder, you mentioned pre-packs, and obviously a lot of pre-packs are to connected parties. I wonder whether the new regulations, which came in I think in April last year, and the requirement to get either creditor approval or the evaluator's report, might impinge on those pre-packs to connected parties, and whether or not that might tip the balance back towards CVAs. I guess it's perhaps a little bit early to tell how that's going to operate in practice.
I think at this stage it's a bit too early, and obviously we've got so many different factors in play that have protected companies from needing to seek support. Yeah, you'd hope it could push people back towards the CVA, but as I said, some of the behaviours we've seen around the rise of the pre-pack liquidation, you wonder whether certainly those smaller company CVAs actually could push the other way potentially.
Yes, and so what's the if you had a magic wand, what's the single thing you think would be most, if you could change or introduce, which would facilitate the use of the CVA, which, as we discussed, can be a relatively cheap, useful tool if it's used in the right case in the right way?
I think that there's possibly not one thing, but I think there's a few small wins. So I think the role of HMRC is important, and that was important before the change in the preferential status of the Crown. So I think having the Crown being willing to take a sort of a commercial view on things would be important, perhaps willing to stand back from that status as well. I think as well, being more realistic about what's possible in a CVA. So agreeing to be bound by terms for 5 years just isn't going to be realistic for a company that's struggled to make it to 2 years since it was incorporated. So I think sort of shorter terms and creditors accepting the fact that what perhaps doesn't look like a great return is going to be better than you might have in a liquidation or a pre-pack. And that's realistically, if you have a CVA that falls over within 18 to 24 months, then you're not really going to have collected much by way of dividends, and you're likely to flip into another process which may pay very little as well. So I think it's been more realistic on all parts, really. Yes,
thank you for that, Chris. Tony or Chris, did you have any comments or questions for each other?
Just the thought, and this really for other people as well can comment on this if they want to, but what was threatened from the middle of 2020 onwards in a lot of discussions was there'd be this wall of insolvency when the pandemic restrictions on presenting winding up petitions came to an end, that we'd see this sudden everyone coming back to the courts in great numbers. Now that hasn't happened, and it's now 2 years on, still it hasn't happened. But I wondered, in a circumstance where you have some major external factor which has caused insolvencies across the economy, the CVA, a consensual approach to enabling people to come out of that and maybe postpone the payment of debt once it becomes something which people can pursue. That consensual approach, I was wondering about how there may be a way in which that can be done across chains of supply. We talk about groups of companies going into insolvency, but we have no procedures for not groups of companies, but chains of companies involved in a supply. X can't pay its debts because Y hasn't paid it. Y can't pay that debt because Z hasn't paid it. Liquidation is not a sensible answer to all of that because we don't have the procedures within liquidation to cope with that. But I wondered if you have any thoughts, Chris, about how we might be able to use CVAs in that context.
I suppose one of the beauties of the CVA, but also one of the challenges, is the fact that each one is bespoke and unique, and that can create some challenges. So perhaps a degree of uniformity in the documentation might facilitate that. I know R3 has published some standard form documentation to try and make access to CVAs easier and more cost effective. Perhaps that might be a starting point, that if you can remove some of the disparities between different CVAs and the unique elements of them, and they're more consistent, that might facilitate this sort of more global approach to engaging with them.
Good. Thank you. I think we're coming up to around about the hour. Don't think we've got any more questions at the moment. So unless anyone's going to come in the next few seconds or so, I'd like to thank both of you very much for your time and for your contributions this evening. It's been very valuable and interesting, and I hope people in the audience have found it useful and made them think about things in a different way. I'd like to thank everyone for signing up and attending. If people have enjoyed this or not enjoyed it, or have questions or further questions for any of us, they can email me at chairman@mccba.co.uk, and that'd be interesting to see what people think. No more questions in, so I'd like to again thank you both and wish everyone a good evening.
Thank you very much. Bye.